Good morning, Your Honor. Not today, as not on behalf of the people, P88493.
James Suzuki, on behalf of the defendant.
Mr. Martin. All right, Mr. Martin, can you tell me your first and last name?
First, I object. I'm not the defendant here.
Then I'm going to issue a bench warrant for your arrest. You're here. I'll recognize you. You're Mr. Martin. Okay. I understand. Let me ask a few preliminary questions. I know, Mr. Gazicki, you need to make a record. Is the complaining witness present for today's bench trial? Okay, okay, thank you.
Two issues. One on discovery. We were here about 2 weeks ago. I did receive discovery. I believe it was like June 23rd or so on. I've been on vacation since the 3rd of July until yesterday. I had no opportunity to go down to the jail to visit Mr. Martin. But with, today I handed him a redacted copy because according to the discovery procedures in Wayne County, the only files I can share with the defendant are redacted. As far as the video goes, I have no other means to, redact that, to show that, or to give him a copy. Today I handed Mr. Martin a redacted copy of the police report that I did have. Okay. With that aside, Your Honor, I do want to make a motion to withdraw. I have had contact with Mr. Martin in the past and ended up with the same position I am right now.
And here we go, and Martin's attorney has officially had enough, asking the court to withdraw because there's zero communication between them. This is what's called a breakdown of the attorney-client relationship. In legal terms, once trust is gone, the lawyer can't effectively represent their client. Notice how Martin flips the narrative, though. He claims the attorney isn't doing his job, while the lawyer says Martin won't cooperate. Classic finger pointing. But here's the kicker. Martin insists he'll file his own motions, which the judge immediately reminds him can't just be frivolous filings. What do you think? Was the lawyer really slacking, or is Martin sabotaging his own defense?
There's no communication between the two of us. There's, different thoughts on how to proceed and so on that I cannot adhere to. So I'm asking the court to withdraw on this matter.
Mr. Martin, have you had a breakdown with your attorney?
No, he's not doing his job. So like as he admitted, he hasn't brought me to discovery. So I just told him I'll file a motion to dismiss the case then based on the ineffective assistance of counsel.
Okay, well, you can't dismiss a case on that. I'm asking you a specific question as it relates to Mr. Gazicki. Do you want him removed from your case?
As long as he's not going to do nothing that's going to jeopardize the case further, like try to delay, like he asked me, do you want to do adjournment? I said, no, I'm not doing no adjournment on the trial. I'm going to just sit in jail while I'm waiting. So I don't consent to him doing nothing that's going to jeopardize or violate my rights. But as long as he's doing, what he's supposed to besides it, I have no problem with it. But...
Well, you understand, Mr. Martin, I've told you this previously. Attorneys it's against the court rules for them to file frivolous motions. So Mr. Gazicki cannot, as your attorney, make motions that are frivolous. And some of the motions that you've previously presented to this court are in fact frivolous. Okay, I have jurisdiction. So if you're asking Mr. Gazicki to file a motion on the basis of jurisdiction, he cannot do that. Do you understand what I'm telling you?
No, one, I didn't ask him to file a motion specific to no jurisdiction.
Well, you've asked him to file a motion to dismiss today.
No, I didn't ask him. I just told him I was going to do it myself. I was going to file the motion to dismiss the case because of this ineffective counsel not providing.
Okay, that's not a reason for a dismissal.
Sure.
Okay, so Mr. Martin.
I'm going to move. Well, if it's right now, I'm going to move for that. That's why we're talking about. Or
okay, denied. What's your next one?
Based on what reasons?
Okay, so do you want Mr. Gazicki to represent you or not? Yes or no?
I'm going to say no.
Okay, there's been a material breakdown of the attorney-client relationship based on both counsel and Mr. Martin's assertions. So Mr. Gazicki is withdrawn from the case.
Thank you, Your Honor.
Yep, thank you. Now, Mr. Martin, you have to make some decisions. Do you want an attorney appointed to represent you on this? I know
Unless one's immediately right now, no, because I'm not going to allow a delay in this case due to,
Well,
these
Mr.
incompetent
Martin,
attorneys not doing their jobs constantly.
Mr. Martin, you have a constitutional right to an attorney. If you can't afford one, I will appoint one for you. Do you understand that?
I comprehend that, yeah.
Okay,
But-
so here's the thing. I don't want you to say that you don't want an attorney because you want to go to trial right now. Unless you have a true understanding of what that means. Because you can't go back later and say, well, now I want to appeal because I wasn't given counsel because I said I didn't want counsel because I want to go to court right now. Do you understand that?
Well,
I'm happy to adjourn this for a week
but
so that you can have an attorney.
why I sit in jail, no, that's, I don't agree with that, so no, I can.
Oh, this is where the stakes shoot through the roof. Martin refuses another attorney, saying he's tired of delays and boldly claims he'll represent himself. Legally, defendants do have a constitutional right to self-representation, but it's a dangerous road. Judges often warn defendants, like you just heard, that they'll be held to the same standards as trained lawyers. No excuses. Think about it. Martin may know some law from the prison library, but can he really match the experience of a real attorney in a live courtroom? Be honest. If you are facing serious charges, would you take that gamble or let a professional fight for you?
Present myself, I've been doing all 30 years, studying, practicing.
Well, it's not been going very well for you, Mr. Martin. It might be time for you to get an attorney.
No, I don't agree with that. I've been beating several cases myself,
Okay.
so but regardless of that, this is a simple case anyways.
All right, Mr. Martin, listen to me. You understand, I want you to understand a few things, okay? Again, you have a right to an attorney at public expense. We could expedite this case and put it on a docket right away. It's a bench trial. So I could get you on, next week or later this week. I'm not certain if that's possible. It would likely be next week so that you could have a lawyer and that lawyer could represent you. And I want you to think about that because
Okay.
Mr. Martin, if you have a constitutional right to a lawyer or to represent yourself if that's what you want to do. But I need you to take the passion out of it, take the heat out of it for a minute and think about what you want to do as a smart decision. Do you want to wait a week for a trial and have an attorney present or not?
No, I don't want to delay this because there's no guarantee the next attorney may do the same thing, just keep on not doing their job and then think they're gonna delay me, so no, I'm ready to go forward and, I have,
You understand, Mr. Martin, that if you chose to represent yourself at this hearing, you're held to the same standards as an attorney. And do you understand that?
no, objected under Haynes versus Kerner, US Supreme Court case. Pro se litigants are held to less stringent standards than formal pleadings drafted by lawyers.
Okay, well, this isn't a formal pleading. These are questionings of
Well, present
witnesses.
themselves the same
Well,
thing.
no, it's not the same. I want you to listen, Mr. Martin. I'm trying to make sure your rights are protected right now. I'm asking you to get an attorney. You've indicated you want to proceed without one. And I'm asking that you understand, I'm not going to allow you to get up here and ask questions in a way that are inappropriate to witnesses. You can ask questions, you can get answers, you can ask more questions. But I'm not going to allow this to meander into something that it's not. Do you understand that?
And there it is, the ultimate jailhouse lawyer line. Martin proudly says he studied law every day for 24 years in prison. Now, sure, some inmates do become pretty skilled at legal research, but studying cases and actually arguing in front of a judge are two very different things. This is where reality hits. Knowledge without strategy, training, or credibility doesn't usually win trials. You can almost hear the judge's patience evaporating when she asks if he went to law school. Her point is clear. Book knowledge doesn't equal courtroom power. Do you think Martin is delusional here, or is he really as sharp as he believes?
Well, I do my best. If it, if there's something, that comes that you let me know or whatever, but of course I know the basics of presenting a case, be it criminal or civil, so,
Did you go to college for 7 years to be a lawyer?
Not official college, but when I was in prison 24 years, I studied the law library for 24 years straight.
Okay.
30 years now counting, being out, so
Okay,
there might be a
that's
few
your
things I might
choice.
forget.
If that's, Mr. Martin, I'm not, look, you and I have gone back and forth for several hearings at this point. I'm not going to change your mind on things. I know that, right?
Right, yeah.
You have a right to a trial. You have a right to a trial by jury or judge. You've previously waived your right to a trial by jury. Is that correct?
Right, yeah.
Okay. And so
Since
here
I'm
we,
not gonna get a jury by like I really want, a jury of my peers to be those of the sovereign people, since that was denied before Slayton's court. Same.
yeah, it's, do you know, where am I supposed to go to get a judge of, a jury of sovereign citizens? I mean, that's not how it works. That's not what the Constitution requires. So you're waiving your right to a trial by jury, correct?
Only because, like I said, I can't get a jury by my peers of sovereign people. so
Oh, okay. And are you waiving your right to an attorney?
As of now, but let's say, worst case, let's say even though I shouldn't, there's no evidence, or even if it was to be guilty, I would then want an attorney to represent me on appeal, I'll say that. but-
Okay, well, I want you to know that you would have a constitutional right to have that attorney too.
Right.
And
But
if
as
you're
of now,
found-
no, because these attorneys keep, like I said, they keep doing this, it's
Okay.
constant.
Okay,
You know, that I've been having, not doing their job and holding me up, I'm not.
Okay. All right. Is there another, Officer Frisky, Officer Kemp, can you come up for a second? If you can stay with the prisoner.
But also I need,
Give me a second, okay?
So what did we just witness? A defendant who refuses to accept legal help, insists he can outsmart the system, and constantly clashes with the judge over rules that aren't up for debate. Judge after judge has warned Martin that he's playing with fire, but he still insists on calling the shots. Cases like this highlight the tension between a defendant's right to control their own defense and the court's duty to ensure fairness and efficiency. And here's the big question. Was Martin defending his rights or digging his own legal grave? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.